The Louisiana law of navigable and non-navigable waters. Non-navigable waters and water bottoms. Ownership of inland non-navigable water bottoms. Inland non-navigable water bodies are those which are not navigable in fact and are not sea, arms of the sea or seashore. B. Inland non-navigable water beds or bottoms are private things and may be owned by private persons or by the state, and it is political subdivisions in their capacity as private lessons. B. Navigable waters and water bottoms. 1. Legal doctrines. A. Inherent sovereignty. 1. When the American Revolution occurred, each state became sovereign and acquired the ownership of navigable waters in the state of the soils under them. Martin v. Waddles for lessee. 2. The inherent sovereignty of all states and the state of citizens are known the beds. Citizens own the beds and the bottoms of all navigable waterways in existence of the date of statehood. State v. Placid Oil Company. 3. By virtue of its inherent sovereignty, the state acquired the federal government the beds and bottoms of all navigable water bottoms in the state, whether lakes, rivers, and other streams, up to the ordinary high water mark upon the state's admission to the Union in 1812. Shively v. Bowlby. B. Equal footing doctrine. Now, new states are admitted to the Union on an equal footing with the original 13. Pollard v. Hagan. Number 2. The state of Louisiana in 1812 acquired title to all lands within its boundaries below the ordinary high water mark of navigable bodies and water by virtue of the equal footing doctrine. The inherent sovereignty of all states dictates that the state and its citizens own the beds and bottoms of all navigable waterways in existence on the date of statehood. State v. Placid Oil Company. C. Public trust doctrine. States upon entering the Union were given ownership over all lands beneath the waters, subject to the tide's influence, that the lands became property of the state upon its admission to the Union. Phillips Petroleum Company v. Mississippi. 2. Navigable water bottoms cannot be alienated by the state. The legislature shall neither alienate nor authorize the alienation of the bed of a navigable water body, except for the purposes of reclamation by the riparian owner to recover land lost through erosion. This section shall not prevent the leasing of state lands or water bottoms for mineral or other purposes. Except as provided in this section, the bed of a navigable water body may be reclaimed only for public use. A. Historical. Nor shall the legislature alienate or authorize the alienation of the fee of the bed of any navigable stream, lake, or other body of water except for the purposes of reclamation. 3. Natural navigable water bottoms are public things. Public things are owned by the state and its political subdivision in their capacity as public persons. Public things that belong to the state are such as running waters, the waters and bottoms of natural navigable water bodies, the territorial sea, and the seashore. Public things that may belong to political subdivisions of the state are such as streets and public squares. 4. Ownership of waters and beds. Historical developments. A. Public policy against private ownership. Evidence of the strong public policy against private ownership of navigable water bodies embodied in the Civil Code articles is found in a series of legislative enactments, recognizing explicitly or implicitly that such property is owned by the state as inalienable public things. 1. The first enactment of this type was Act Number 247 in 1855, which recognized that if any of the lands acquired through the Acts of Congress of 1849 and 1850 contained navigable waters, the land under those waters would not be subject to sale along the swamp and overflow land that were to be sold. 2. Next Act of 124 in 1862 recognized that the bottoms of navigable lakes were insusceptible of private ownership by providing that once natural causes rendered dry beds of navigable lakes, they became swamplands and were susceptible of alienation. A. One authority has noted that these two statutes reveal that the legislature in 1855 and 1862 was keenly aware of the prior existence of the public policy of the state that the bed's navigable water bodies are inalienable and insusceptible of private ownership. J. Madden Federal and State Lands in Louisiana 331. Thirdly, Act number 75 of 1880, the legislature did not enunciate as specific a recognition of the public policy as it had in the two previous statutes, but it did exercise extreme caution in providing that the lands it authorized to be sold where only this received by the state under the Swamp Lands Act of 1849 and 1850. These specific restriction evidences an intent to make certain that inalienable waterbeds were excluded in recognition of the public policy emanating from the Civil Code. B. The Oyster Statutes. Now, the Oyster Statutes were passed by legislature over the next 50 years. Each of the following enactments provided the beds of the certain navigable waterways near the Gulf of Mexico shall be and will continue to be the property of the state of Louisiana. Acts number 106 of 1886, 110 of 1892, 121 in 1896, 153 in 1902, 52 in 1904, Act number 189 in 1910, Act 54 of 1914, Act number 139 in 1924, and 67 of 1932. Now, Act 258 of 1910. The waters of and in all bayous, rivers, streams, lagoons, lakes, and bays, and the bays thereof, not under the direct ownership of any person, on August 12, 1910, are declared to be the property of the state. There shall never be any charge assessed any person for those use of the body waters or the state of municipal, industrial, agricultural, or domestic purposes. While acknowledging the absolute supremacy of the United States of America over the navigation on the navigable waters within the borders of the state, it is hereby declared that the ownership of the water itself and the beds thereof in said navigable waters is vested in the state, and that the state has the right to enter of possession of these waters when not interfering with the control of navigation exercised thereon by the United States of America. This section shall not affect the acquisition of property by alluvion or accretion. All transfers and conveyances, or purported transfers and conveyances made by the state of Louisiana to any levee district of the state of any navigable waters and the beds and bottoms thereof are hereby rescinded, revoked, and canceled. Now, this section is not intended to interfere with the acquisition in good faith of any waters or the beds thereof transferred by the state or its agencies prior to the August 12, 1910, as amended in Acts 1954, number 443, section 1. Now, number 1, Act number 258 of 1910 affirmed that the right of ownership of the beds of the navigable streams is vested in the state. Gulf Oil Company v. State Mineral Board. 2, the water bottom of a navigable lake or arm of the sea is reserved by the language of the patent and is moreover non-transferable. Gulf Oil Corp. v. State Mineral Body. Letter D. Act 32 of 1912, Statute of Repose. Actions included by the state Louisiana to annul by any patent issued by the state, duly signed by the governor and the register of the state land office of the record in the state of the land office, are prescribed in 6 years, reckoning from the day of the issuance. 1. Act number 62 is not ratification of conveyances of navigable water bodies because statutes should be interpreted in light of the state's public policy. Gulf Oil Corp. v. State Mineral Board. See Article 4, Section 2 of the 1921 Constitution. Nor shall the legislature alienate or authorize alienation of the fee of the bed, any navigable stream, lake, or other body of water, except for the purposes of reclamation. In all cases, the mineral rights on any and all property sold by the state shall be reserved, except where the owner or other person having the right to redeem may buy or redeem property sold or adjudicated to the state for taxes. California Company v. Price, 1953. In 1953, the Louisiana Supreme Court rendered a decision that created immediate controversy. This case was California Company v. Price, and may be summarized as follows. The Price case was brought as a concursus proceeding to determine the ownership of funds representing accumulated oil royalties from wells drilled in Grand Bay, which was an arm of the sea. Both the state of Louisiana and their heirs and successors of the individual who had received the patent from the state claimed the funds. The patent was executed by the state to the ancestor in title of the heirs in 1874. It included a portion of Grand Bay, a navigable bay that was an arm of the sea. It was regular on its face, properly recorded, and supported by consideration. The Supreme Court ruled that the state had transferred ownership of a portion of the Grand Bay to the patentee. The patent was tactically confirmed and rendered unassailable by inaction of the state pursuant to the provisions of Act 62 of 1912. It held that the legislature, prior to the adoption of the Constitution in 1921, had the right to sanction the conveyance of submerged lands, notwithstanding any codal concept of public policy to the contrary, since there was no constitutional restraint on the power of the legislature to dispose of navigable water bottoms of the state prior to the adoption of the Constitution of 1921, and the 6-year prescriptive period had run. The state was stopped from attacking the validity of the patent. Public policy that navigable waters and the beds thereof are public things. 1. The implications of this decision could have had a disastrous impact on oil and gas revenues in the state of Louisiana. Accordingly, the legislature of 1954 passed an Act 727, which legislatively attempted to overturn the Price case. The eventual impact was an overruling of the Price decision in 1974 by the Gulf Oil Corporation case. Number 2, it has been the public policy of the state of Louisiana at all times since its admission to the Union that all navigable waters and the beds of same within the boundaries are common or public things and insusceptible of private ownership, that no act of the legislature of Louisiana has been enacted in contravention of said policy, and that the intent of the legislator of the state at the time of the enactment of Act number 62 of the year 1912, now appearing and continuously thereafter, was and is at the present time to ratify and confirm only the patentees which conveyed or purported to convey public lands susceptible of private ownership of the nature of character, the alienation or transfer of which was authorized by the law, but not patents, or transfers which propose to convey or transfer navigable waters and the beds of the same. See the 1937 case, Miami Corporation v. State. The Supreme Court noted the private ownership of the beds of the navigable waters is forbidden by and, quote, contrary to the whole spirit of the code, it is held that it is the rule of property and of title in the state, and also as a rule of public policy that the state as a sovereignty holds title to the beds of navigable bodies of water. B. If something is public, it cannot be alienated or appropriated for private use. 3. Patents transferring navigable waters are null and void. Any patent or transfer hereto or hereafter issued or made is null and void, so far as same purports to include such navigable waters and the beds thereof, as having been issued or made a contravention of the public policy of the state and without prior authorization by law, provided by the provisions of this section, shall not affect the laws of accretion or apply to lands that were susceptible to private ownership on this date of the patent or transfer by the state or a state agency. A. Patents conveying state property to private individuals are ineffective insofar as they purport to alienate the beds of navigable waters. And that Act number 62 of 1912 did not have the effect of ratifying such absolutely null transfer. B. But see the 1984 case, Terranbon v. South Lafourche Title Council. Even interpretive legislation cannot operate to disturb already vested rights. The legislator cannot retroactively affect, under the guise of interpretive legislation, substantive rights vested under earlier unambiguous legislation. There is no prescription to cure patents conveying navigable waters. No statute enacted by the legislature of Louisiana shall be construed to validate by reason of prescription or preemption, any patent or transfer issued by the state, or any levy district thereof. So far, the same purports to include navigable or tide waters of the beds of the same.